Hello, my name is Linda Cheek, MD. I use MD with the permission of my judge, the Honorable Glenn Conrad, who stated when I asked him that even though I can't practice medicine, I have the degree and am entitled to use it. I use it only, however, when I am involved in my work pertaining to correcting these wrongs being done to physicians today, or promoting the concept of energy medicine over conventional without actual patient treatment. I have been the interviewer of the other doctors in the segments on doctors who treat chronic pain for the week of Chronic Pain Advocacy Week. Only one of the other 4 doctors, however, was subjected to the unbelievable government misconduct called a trial, as I was. But the interviews show from the other 3 that those doctors are just as aware now of what is going on, based simply on the charges levied against them and the destruction of their lives so far by the government or medical board. Now I want to clarify some of the points made during their interviews and shed some light on how the laws in this country are being flagrantly abused or even illegally created by an out-of-control justice system without any repercussion. The actions brought to light by Sidney Powell in her book License to Lie show that the illegal actions of the Department of Justice, abbreviated in future reference DOJ, is now more of the rule than the exception. We are no longer a country of law, but a lawless government camouflaged by the impression of law, with a Justice Department that covers up its own illegal actions against innocent, targeted citizens. And for what? Money, power, promotions. First, let me give you a little background on myself and my case. I graduated from medical school at the age of 43 in 1992, after first being an Air Force spouse and high school teacher for 20 years. Now, due to my being a second career physician, I had a life experience behind me, knowledge of home remedies throughout my life, and I knew that as the conventional professors taught us in medical school, that there was a lot of healing knowledge that they did not even know about. For my medical residency and also my practice, I chose to return to Virginia. For my practice, I decided to work in a medically underserved area because at the age of 45, when I finished my residency, I was more interested in helping people than in creating a lot of wealth for myself. Now, within the first 2 years of my practice, I recognized the fact that conventional medicine doesn't cure anything. The advertising of drugs now, saying they cure hepatitis C and other autoimmune disorders, is a farce, by the way. These drugs simply turn off the body's natural processes of recognizing foreign substances. But that's food for another discussion. When I started diagnosing disease for the first time and using drugs for things like hypertension and diabetes, for example, and I saw that there was no cure possible using these drugs, we were simply maintaining the disease process and it would just continue to worsen, I started down the road to learn alternative medicine. I started with acupuncture, and that led me into a world of all forms of energy medicine, auricular therapy, homeopathy, and so on. I also learned prolotherapy that actually can heal any type of joint problem. Energy medicine is the medicine of healing. It has been squelched, however, through politics and law, and conventional medicine is currently the only medicine. But we as citizens need to change that. But again, that's another topic. But through my studies, however, I found energy medicine and was using it. And I used it completely lawfully. I never charged insurance for anything pertaining to my alternative medicine. That was always addressed to the patient as, this is not covered by insurance and you will have to pay extra for it. I actually helped heal people from disease, but I was a persona non grata in the area. You see, the hospital in that area was a part of Columbia HCA, a hospital chain throughout the country owned by Thomas Frist Jr., the brother of Senator Bill Frist from Tennessee, who had brought me, the hospital itself had brought me into the area fraudulently. You see, they did this in the hospitals in our area. I do not know about other areas, but they did it fraudulently, bringing unsuspecting physicians in to join a doctor's practice, giving that doctor kickback money, so to speak, for, quote, employing a new physician, But then once that physician's time was up, the physician was basically forced out, forced to move away, and another doctor repeated the process. So basically, there were a few doctors in the area that were getting these fraudulent kickbacks from this hospital chain. So when I lost my position with the doctor that they brought me in to join, they obviously wanted me to leave like all the other doctors had done. But I couldn't because I was a female physician with a husband who worked at an area university. So I opened up an independent practice. Now, during that time, they worked through innuendo and slander to try to ruin my independent practice. But with the course of my learning energy medicine and how people can be healed, I started treating pain. And I did it legitimately, and I was actually healing people and getting them off of their opiates. But, in my opinion, government and hospitals work together. So, surprise, surprise, the United States government targets me for Medicare fraud. This happened, the course of the raid on my office was in 2006. But years prior to that, I had 3 consecutive years where Medicare requested records of mine to be audited. And when I finally called them and asked them why was I being audited 3 years in a row, their response was a cover-up. They said it was simply random, that they weren't looking for anything in particular. All lies. But because I used a computer patient record, I documented everything, crossed every T and dotted every I, they had to create illegalities to charge me with. Now that is covered more in depth on doctorsofcourage.org under my name, under Doctors Charged. But the point is that if the government targets you, you have no chance. They have all the money, the ability to use prosecutorial misconduct, and media propaganda to make a fair trial impossible. I recognized that, and even though I was innocent, I pleaded guilty to fraud, thinking that that would be the end. But it wasn't. The misconduct of U.S. Attorney John Brownlee, anticipating an appointment to judgeship, and his henchman, Assistant U.S. Attorney Pat Hogaboom, put charges on record that were complete lies. Now, even though I pled guilty and had my license revoked, it was reinstated 9 months later, but I found out that once you have relinquished your DEA certificate, you won't get it back. But the DEA isn't willing to be honest with doctors because of the chance again attacking a doctor and running salaries for another 2-year investigation. Now, in my case, the DEA stonewalled my questions about how I was trying to take care of the chronic pain patients that were unable to find any treatment in the area. Again, this story is covered on doctorsofcourage.org. But the finding of a doctor willing and able to step in and run the practice in my place was evidence of God's presence in the situation. And in spite of everything that happened to me, that fact has never left me. God had no intention of leaving these patients without pain management. He provided the care in an amazing example of a miracle. That miracle and that story is actually portrayed in a novel that I wrote, which is fictional, but the information that the fiction is based on was my story. But being a godless government, the efforts of my care was confounded with the intended second attack on me. Now, this second attack is a prime example of government misconduct. For example, my nurse was held in an interrogation room for 6 hours. She was told by law enforcement what they wanted her to say. Because it was all lies, she refused. She was then threatened that if she didn't testify to the lies, that she would go to prison. Most people will succumb to that pressure, but she didn't. She said, "Go ahead and put me in prison." She refused to lie for them. But even then, even though she was really a defense witness, the government still listed her as a prosecution witness so that I, the defendant, could not talk with her. Now there steps in the position of what my defense attorney is supposed to do, but that's another complete fallacy, that we actually have attorneys willing to defend us. My defense attorney, Rhonda Overstreet of Bedford, Virginia, and also working pretty much throughout all of Southwest Virginia, it was her job to communicate with these government witnesses and get them to talk with her so that she could understand their stories and formulate a defense for me. She claimed to have called them, but after the trial, when I was able to talk to these, quote, government witnesses, unquote, that were really my friends and should have been my witnesses, I found out she never communicated with them. That wasn't the plan. You see, defense attorneys actually work for the government. Now, I wasn't as lucky with a primary government witness as I was with my nurse, the doctor that treated the pain patients. Now, we did everything we knew to protect her and maintain her autonomy. She ran her own business. I referred the patients to her who needed pain management. She made all the decisions. But at the age of 78, she did not have the strength or mental capacity to fight the onslaught of illegal witness tampering. I'll go into what I found out after the trial later. She stated on the witness stand that I never communicated with her about patients, but since I had phone records showing calls that were made on those days when the prescriptions were called in, that would have been easy to show that false testimony. But there again, where your defense attorney is supposed to step up to the plate to defend you, mine didn't. She refused to even show the jury the phone records. She made some lousy excuse of, well, you really didn't talk to her long enough. It doesn't take that long for a doctor to determine a pain medicine needs to be prescribed for someone who is in frank withdrawal because of another doctor's office being closed. So anyway, that testimony ended up standing. Now, one of the requirements in criminal court is that the defendant knowingly and willingly commits these illegal acts. But the government doesn't have to prove that. Just stating it as an opinion in their closing argument is enough to get the indictment, or to get the conviction, They put all the information that I had given, sent the DEA requesting information, requesting instructions, informing them of what Dr. Schultz and I were doing to evaluate and treat patients. We were completely transparent. And they put all of this up in the courtroom. And they actually were defending me and my actions. So I really never did understand how the jury ever convicted me, and yet I was convicted. Part of that, I believe, is because I did not testify. Again, because she was actually part of the government plan, my attorney recommended to me that I not testify. What I found out is that our concept in this country is no longer innocent until proven guilty, but guilty until proven innocent. The average citizen actually believes that the people in the Department of Justice have integrity and would not attack an innocent person. Just being in the defendant's chair makes you guilty. And if you don't prove that you are innocent, you will be convicted. But because everyone working in your office is either charged as a conspirator, threatened to be charged if they don't cooperate and lie on the witness stand, or simply listed as a government witness, the defense has nothing with which to prove innocence. They can only rebut the government's testimony. To change this, we must make it imperative that the defendant has first dibs on witnesses. Then it will be required of the U.S. Attorney's Office to only interrogate those witnesses in the presence of the defense attorney. That way they can't intimidate or threaten people to commit perjury. In this interview, I hope to explain to some degree how the laws are being flagrantly misused to convict innocent physicians. This is being done by what is called case law at the lower court level, regardless of what the Supreme Court has decreed. Case law is law not issued by the legislation, but by court decision. Case law has its origin in common law, going back hundreds of years in England. But now, case law from the Supreme Court is being ignored, with the unlimited authority to break laws being given to the U.S. attorneys today. But first, a short history lesson. Did you know that all legislation pertaining to controlled drugs has a racial basis? Starting with the Harrison Act of 1914, recreational drug use at that time was considered an action by minority populations and was therefore criminalized. It didn't stop abuse because drugs don't cause abuse. But because conventional medicine, hospitals, doctors' organizations, big pharma, and the government are all wrapped around making money off of drug abuse, the real cause isn't being recognized. Instead, more money is being made by creating laws that can be misused in courts, creating case law at the lower court levels to put innocent people in prison. It's a racket. In 1970, the legislature saw the possibility of forfeiting money made by the drug cartels selling illegal drugs in the United States. So they created the Controlled Substances Act, or Title 21 of the United States Criminal Code, which I will further call the CSA. As a result of the CSA, eventually the DEA, or Drug Enforcement Agency, was created as an agency to supervise the scheduling and enforcement of controlled drugs. Again, more justification in keeping the myth of drugs causing addiction alive. More jobs, more money, more power. and they have grown more and more out of control ever since. Now, realistically, the government found out that they really couldn't confiscate the cartel's assets because they weren't located in the states. So at some point in the late 20th century, some smart U.S. attorney said, hey, we can confiscate doctors' assets if we just charge them with dealing in drugs. And to do that, they had to revamp the paragraph in the Controlled Substance Act exempting physicians. I will go more into that in the future. But to show how the laws being used against doctors are actually laws designed to go after drug lords and criminals, the sentencing guidelines of the CSA are based on milligrams of marijuana, which, to be able to be covered doctors' prescriptions, have been converted to an equivalence into one prescribable drug, oxycodone. So when you see a news article about a doctor being charged with, quote, oxycodone distribution, it doesn't necessarily mean that it is the drug oxycodone, but it can be any Schedule 2 through 5 drug covered by the CSA, even down to chloral hydrate, which is prescribed to children to help them sleep. That, in and of itself, creates an unfavorable prejudice against the doctor in court, because through government propaganda against OxyContin for money, people just automatically consider that term, oxycodone distribution, to be criminal and derogatory. Now, for my story, based on the prescriptions that were ordered by Dr. Schultz, a doctor with a DEA certificate and licensed to prescribe them, I was charged with 86 counts of oxycodone distribution and 86 counts of using a number issued to another person. Now, none of those prescriptions were for oxycodone to my recollection. They were Lortab and even benzos that Dr. Schultz might have ordered by phone, because she couldn't order Schedule 2s by phone, and she only ordered enough to help the patient until the patient could be seen by her if they were a new patient. Now, the last count on my indictment was the purpose for the whole proceeding, declaring my office as a place for drug dealing. You see, that allows for forfeiture by the Controlled Substance Act. The whole purpose of the Controlled Substance Act was to forfeit the cartel's assets. So now, by using that particular law against physicians, allows for the forfeiture of all property. Now, as already mentioned in the interview of Dr. X, even though the jury found me not guilty of using my office to commit a crime, the judge turned that decision around, made me guilty, so that the purpose of my going to trial would be a success. The government could then forfeit my office building. But not only that, they're so brazen that in spite of my husband's request while I was incarcerated to go into the building and remove my personal belongings, the government refused. So everything in the office was lost when the government sold my building, which, by the way, was sold before I had gone through the appeals process. That's how brazenly assured the government is of support by the upper courts. In other words, the government stole property of mine that had nothing to do with the medical office, sold it, made money, and got away with the theft. No one cares. No attorney is willing to take the case against the government. Basically, the government can steal from you, make you a criminal through gross government misconduct, ruin your life, destroy your family, and walk away not only stock-free, but with accolades and promotions. Now I want to go into the methods that the government uses to convict innocent physicians, and how they completely ignore Supreme Court case law to do so. I have this information because during my incarceration of 28 months, I did do things to help my own personal life, but one of the things that I did was research. I went into the law library and researched, primarily because I had to be my own lawyer for my petition for certiorari for the Supreme Court. So in all of this research, I learned the laws pertaining to this and how they are not being followed by the Department of Justice. In United States versus Roth, for example, the Supreme Court ruled that deliberate perjury to the grand jury may result in dismissal of charges. So right off, from the word go, my case should have been dismissed. In my case, the only grand jury testimony that was in any way injurious to me was that of the DEA agent Stephen Tomaszewski. He intentionally misled the jury to assume that there was intentional illegal activity being committed by saying that I knowingly gave prescriptions to drug abusers. Now, of course, that was not true, but at the time of grand jury, there is no defendant lawyer present. This is only what the government can tell the grand jury, and they are licensed now to give whatever lies they want to get a person indicted. Now, the main doctor that the government used against me in the trial, she said nothing injurious to me at the time of the grand jury testimony. She never made any claim of impropriety. It took a year or more of the government interrogating her, threatening her, and creating gross, outrageous government conduct, actually creating her testimony for the trial. And then, at that time, through government coercion, she perjured herself. Now, in evidence of this, Dr. Schultz was scheduled to be a witness for the petitioner at the DEA hearing in October of 2011, that petitioner being me, for the issue of my certificate. See, the DEA had denied me a certificate based on saying that I was a threat to public interest, which of course was not true, but they can use that phrase illegally as well. And so I had asked for a hearing. She was going to be a witness for me, but because she had not yet been indoctrinated with her planted testimony by the prosecution in preparation for my trial, the night before her testimony before the DEA judge, she was given a letter by the government informing her that she was a government target. So basically what that means is, hey, if you go on the witness stand, we're going to come after you. So that was done to prevent her truthful testimony to become public record. This is a gross miscarriage of justice. If I had been guilty of not communicating with Dr. Schultz about the new patients being accepted by her into her practice, that would have been a main point for the grand jury. But that was never brought up. But instead, they had to commit perjury through Stephen Tomaszewski's testimony to achieve the indictments. Now, also according to U.S. versus Black, it is outrageous for government agents to engineer a criminal enterprise or to use excessive physical or mental coercion to convince an individual to commit a crime. They do this every time they coerce a person to commit perjury to convict an innocent person, doctor or otherwise. It was in total disregard for the law and abuse of power that the government, through its prosecutorial misconduct and illegal direction of Mr. Tomaszewski, that he responded to Dr. Schultz's direct question when she talked to him of whether we should continue to, or stop the protocols and procedures we were using in the office, or whether we should stop doing what we were doing. And on tape, Mr. Tomaszewski stated, "Continue what you are doing." Now, by that statement and his failure to respond to my questions by phone, my questions in person in his office, and my questions by letter to him and to his bosses, all the way up to Washington, D.C., that the government should take full responsibility for any illegal conduct in the evaluation of Dr. Schultz's patients. Now, in Sherman versus U.S., the federal courts have an obligation, this is quote, an obligation to set their face against enforcement of the law by lawless means, or means that violate rationally vindicated standards of justice. At stake is the integrity of the process. It is the responsibility of the court to protect our citizenry from such prostitution of the law. To do otherwise would undermine the court's standing as administrators of justice. If the acts of the authorities are so reprehensible, the problem transcends the individual defendant. The courts would become corrupted by a process that is the fruit of corrupt government methodology, unquote. Now, this is the basis for all the illegal activity being done by the Department of Justice today, and people in America need to understand that our courts are corrupt, and this very statement by the Supreme Court has, in effect, become the rule. The only way I see that we can correct this is we have to stop convicting people in court. The courts have to regain our respect. There's no other way, folks. You cannot sit in a jury box anymore and accept what is being said on the witness stand by government witnesses as being the truth. We have to stop convicting people, even if it means releasing people who have actually committed crimes. The judicial system in our country has got to get lawful again, or our country is doomed. There's just no two ways about it. The problem is Americans are still looking through rose-colored glasses and thinking that our justice system is still based on democracy and fairness, and it's not. Justice in our justice system. But we will find through the court systems today that this case law, as presented by the Supreme Court, is no longer followed. As stated in U.S. v. Rosselli, a landmark case, Justice Rehnquist said, quote, "We may someday be presented with a situation in which the conduct of law enforcement agents is so outrageous that due process principles would absolutely bar the government from invoking judicial process to obtain a conviction." Now, that case could actually be the case of United States versus Linda Suchik. However, this day and time, the Supreme Court isn't interested in justice anymore, and they denied my petition for a writ of certiorari. But, for example, the government never had success sending in an informant into my office. To my knowledge, there were at least 6 tries. So they gave up. What they did to convict me of 2 of the charges against me was that they took the responsibility on themselves of calling in a prescription for controlled substances for one of their confidential sources. Now, since no one in the United States Attorney's Office had an order from a physician to do this, it was an illegal act of the level of outrageous government conduct. Again, this action on the prosecution's part demonstrates pure disregard for the laws of the land and an abuse of power in thinking that they can break the law without punishment, which of course we know, doctors that have been through this, that they can. Another case, Green versus U.S. Government involvement in the operation of an illegal act precludes conviction. And in Olmstead versus the U.S., decency, security, and liberty alike demand that government officials be subjected to the same rules of conduct that are commands to the citizen. So for inciting what the prosecution considers illegal action, and by committing the illegal act of calling in a prescription under a doctor's name, the investigation agent and prosecution of my case should be held accountable and charged with criminal conduct. According to the Supreme Court, government teaches by example. If the government becomes a lawbreaker, it breeds contempt for the law. It breeds anarchy. To declare that the government may commit crimes in order to secure a conviction would bring terrible retribution. That's what's going on today, folks, and we need the terrible retribution to occur. According to Hampton versus the U.S., if the government acts are of greater offense than those of the defendant, the defense of outrageous government conduct is available. And in my case, the only criminal act, the calling in of a prescription not ordered by a physician with the authority to do so, was committed by a government agent working under the orders of the U.S. Attorney. Now, back to U.S. versus Rosselli, the landmark case. It was stated by the Supreme Court that due process represents a profound attitude of fairness between man and man, but more particularly between the individual and government. Due process underlies all of the criminal-related provisions of the Bill of Rights. It embodies the petitioner's procedural and substantive rights. If the substantive rights of a defendant are removed or altered in a corrupt or evil manner, the perfection of process will ratify a corrupt result. Now, of course, that's all legal mumbo-jumbo, and you need to read it in order to possibly understand it. It is available. All of this, all of my discussion here is written on my website, doctorsofcourage.org, under my name, under charged doctors, pertaining to my petition to the Supreme Court. Now, legally, how is the federal government even being allowed to practice medicine in court, stating what is and what isn't, quote, legitimate medical practice? In Linder versus U.S., the Supreme Court stated, direct control of medical practice in the states is beyond the power of the federal government. Congress, therefore, cannot directly restrict the professional judgment of the physician or interfere with its free exercise in the treatment of disease. Federal power is delegated, and its prescribed limits must not be transcended even though the ends seem desirable." Unquote. But in order to not bring these DOJ infractions to justice, the Supreme Court simply refuses to review any of the appealed convictions of doctors, such as mine, the perfect case to point out the illegalities being done by the lower courts. In Heyman v. Galveston, the right of a duly licensed physician to practice his profession is liberty and property within the meaning of the 14th Amendment to the Constitution. And yet, without just cause, the DEA will, without question, withhold a DEA certificate from a qualified physician. Now, without a DEA certificate, the DEA will say, "Oh, you can still practice medicine," but no, not really, because without a DEA certificate, you're not going to get approved by insurance companies. You can't work for the Veterans Administration, medical facilities, or Indian reservations. You can't work on cruise ships or even volunteer organizations like Doctors Without Borders. How do I know this? Because I tried all of the above. I wanted to get out of Southwest Virginia after my first case of accepting a plea agreement for something I didn't do. But I did not have a license. I'm sorry, even when I got my license, I did not have my DEA certificate. Then when they bring me to trial and say that, "Oh, well, I just was a drug dealer in it for the money," making $24,000 a year is in it for the money, sure. But I was a drug dealer because I accepted only cash and didn't accept insurance. Well, the fact, folks, that you didn't give me a lousy DEA certificate prevented me from being accepted by insurance companies. So, where is it my fault that I'm not accepting insurance? Besides, why would I ever want the government to have the right to enter my office again under false pretenses? No doctor in this country should be accepting government insurance because it is a ticket into your office, and once you're targeted, you will be convicted. Now, according to Minnesota ex rel Whipple versus Martinson, quote, "The statute exceeds the authority of the state in the exertion of its police power, in that it undertakes to regulate a lawful business in the manner prescribed in the statute in violation of the 14th Amendment." Again, all of this is evidence of the government staying out of the medical profession. According to U.S. versus Moore, registration of physicians is mandatory if the applicant is authorized to dispense drugs under the law of the state in which he practices. But the DEA completely ignores this law. They choose who they're going to issue a certificate to and who they're not. And it's not based on anything real. It's just based on, we don't want you to have a certificate because we don't want you to prescribe controlled substances. But it's not federal law, it's state law that regulates it. And all of these prior cases say from the Supreme Court level that the federal government cannot prevent a doctor from having a certificate if they are approved by their state. Now, in both Senate and House bills, practitioners and pharmacies are automatically entitled to registration to handle drugs, controlled drugs, Schedules 2 through 5, if they are authorized to dispense under the law of the state in which they practice. And yet the DEA, through this interpretive rule, has taken it upon themselves to deny registration to qualified licensed physicians who have done nothing wrong, and who in fact, like Dr. Cheek and Dr. Ibsen, have actually gotten patients off opiates through alternative medicine, which, by the way, the government is also opposed to for obvious monetary reasons. You can't patent holistic treatments and make money off them. Now, how does the DEA withhold the certificate for prescribing controlled drugs? Through a simple phrase in the CSA, paragraph 824A4, which authorizes the Attorney General to deny, suspend, or revoke a registration that would be, quote, inconsistent with the public interest. But to determine consistency with the public interest, there are 5 factors, of which some are the state's recommendation, compliance with state law, and then public health and safety. Now, in 1971, the Attorney General promulgated a regulation, Title 21 CFR, paragraph 1306, 4A, requiring that prescriptions for Schedule II drugs be used, quote, for a legitimate medical purpose by an individual practitioner acting in the usual course of his professional practice. In 2001, the Attorney General issued an interpretive rule announcing that assisting suicide is, quote, not a legitimate medical purpose. But Gonzalez versus Oregon challenged that interpretive rule, and the Supreme Court affirmed their case. So according to Supreme Court Judges Kennedy, Stevens, O'Connor, Souter, Ginsburg, and Breyer, the CSA did not authorize the Attorney General through interpretive rule to prohibit doctor-assisted suicide because it was state law. The Supreme Court stated that the Controlled Substance Act manifested no intent to regulate the practice of medicine. Quote, in deciding whether the CSA can be read as prohibiting physician-assisted suicide, we look to the statute's text and design. The statute and our case law amply support the conclusion that Congress regulates medical practice insofar as it bars doctors from using their prescription writing powers as a means to engage in illicit drug dealing and trafficking as conventionally understood. That means that the Controlled Substance Act is only designed to attack doctors if they are out on the street corner writing prescriptions for strangers and handing them to them for money, not for patients coming into the office and being evaluated, as they are now attacking us for, using this phrase. You see, by using this phrase the way they have in the courtroom, it doesn't matter what you do. The government can say it's outside of standard medical practice, and the juries believe it. That's where we have to get the change. We have to make the juries stop believing this junk, because it's not true. The statute manifests no intent to regulate the practice of medicine. The structure and operation of the CSA presume and rely upon a functioning medical profession regulated under state powers. The feds need to get out of the practice of medicine. In Linder versus U.S., Congress cannot, under the pretext of executing delegated powers, pass laws for the accomplishment of objects not entrusted to the federal government. But they are doing that now. Any provision of an act of Congress solely to the achievement of something plainly within the power reserved to the states is invalid and cannot be enforced. Obviously, direct control of medical practice in the states is beyond the power of the federal government. However, bills are being written today by Congress and signed into law that make normal medical procedures criminal, and the judicial system will simply turn and look the other way because they will reap the profits. It is for this reason that the American people need to learn the illegality being committed here, inform their legislators to vote no on these bills, and fire them if they don't. I'm going to show you how case law from the Supreme Court is being ignored at the lower court level in the prosecution of innocent physicians. Specifically to my case, in which from the beginning I was stonewalled by the DEA with my questions pertaining to how we were conducting ourselves. All of the conduct for which charges were brought against me were what the law would call, quote, creatures of the agent's purpose. Because you see, they intended to charge me with committing a crime, and so they allowed the continuation of our office procedures to occur in spite of our being transparent and asking them questions to help. Now, pertaining to this comment of creature of an agent's purpose, this comes from Sorrells versus the U.S., in which the criminal acts in the case were called that by the court. And the court called that action a gross abuse of authority. Chief Justice Hughes concluded that to provide the opportunity to commit a crime is beyond reproach. The government may not incite or create crime for the purpose of punishing it. He said, quote, it is unconscionable, contrary to public policy and to the established law of the land, to punish a man for the commission of offense of the like of which he had never been guilty of, if the officers of the law had not inspired, incited, persuaded, and lured him to attempt to commit it, unquote. So if the acts of the prosecutor offend the tribunal, the defendant may not be prosecuted. The courts must be closed to the trial of a crime instigated by the government's own agents. No other issue, no comparison of the equities as between the guilty official and the guilty defendant has any place in the enforcement of this overruling principle of public policy. Now, pertinent to my case, the DEA instructs physicians to present any questions of law to the local DEA agent. Now, I questioned the local DEA agent, Mr. Stephen Tomaszewski, because the certificate that I had applied for was supposed to be issued within 4 to 6 weeks of application, and I wasn't getting it. He stonewalled my questions, refusing to answer them, just simply saying it was under investigation. The petitioner, then went on up the ladder through the DEA organization to his boss, Walter Staples, and even all the way to Washington. And my questions still remained unanswered. Now, finally, I wrote a letter to Mr. Tomaszewski, which the prosecution actually presented to the court, which should have showed my innocence. I explained my frustration at being stonewalled, not comprehending that I was being targeted and set up. I pointed out that I was attempting to do all things according to the law, and if anything was being done that the government could possibly interpret as being against the law, it was the agent and therefore the government responsible for any illegal action that took place. Now, in Virginia Pharmacy Board versus Virginia Consumer Council, quote, information is not in itself harmful, that people will perceive their own best interests if only they are well enough informed, and that the best means to that end is to open the channels of communication rather than to close them. But Mr. Tomaszewski, in conspiracy with the U.S. Attorney's Office, withheld that information that I requested, knowing that if they provided it, then we would have changed our procedures. According to U.S. v. Twigg, when government agents sow the seeds of a crime to lure the defendant to commit the crime, outrageous conduct is being committed. And in U.S. v. Moreno, government agents deliberately orchestrated the elements of the crime. Now, U.S. v. Giannicotti states, quote, a society cannot long remain free if we permit the law enforcer to offer more than an opportunity for transgression. A free society cannot and will not endure if it permits law enforcers to select people arbitrarily and then to proceed by deception to persuade, cajole, entice, and implant a law-breaking disposition that was not theretofore present, when the defendant had absolutely no predisposition to commit a criminal act, and but for the inducement of the government agents, the criminal act would not have been committed. The acts of the government are improper, and the judge should so rule. A person corrupt by a process which only the authorities are licensed to use has been made into a criminal by his own government. This happened to me, and I project that this is going to happen to more doctors with the criminal laws coming out now from the Congress that is making actions in medical offices criminal if, for example, doctors are being charged with criminal activity for treating addicts, like Dr. X mentioned, of the doctor in Philadelphia that has been charged, the addiction specialist, and yet in the laws they are allowing more doctors to prescribe Suboxone and allowing more patients to be prescribed Suboxone. They are setting these doctors up for criminal charges. This should not be permitted. But I will bet you that unless we, the American people, turn this against the Justice Department by so agreeing that they are criminals themselves, putting innocent people in prison for their own promotions and their own justifications, that this will continue. Now, also throughout trials of doctors, the prosecutors are continuously throwing out the phrase, quote, outside the course of professional practice. They do this without any evidence, only their personal opinion. This conduct prejudices the jury, and that's the plan. It is common practice now for them to use this phrase regardless of the fact that they have no evidence, because it reeks of, quote, bad doctor, unquote. Congress pointed out that criminal prosecutors in the past had turned on the opinions of federal prosecutors. And under new acts, physicians that comply with the recommendations made by the Secretary of Health will no longer jeopardize their professional careers. Well, that's a farce. In U.S. versus Moore, there was a doctor, Dr. Moore, that was charged with practicing outside usual professional practice, but he was given the chance to change. Now, he failed to do so, and so he did end up back in court. But if doctors don't know that what they're doing is going to be called outside the course of professional practice, and the prosecutor can say that about anything. They can start saying that about prescribing antibiotics for flu. I mean, come on, folks. Understand the extent of what they are doing. They're going after doctors for money. Where is the limit? There is none. In Boyd versus the United States, the disputed question is whether the defendant issued the scripts in good faith in the course of his practice. That is what we as doctors think is the way things are being done, but it's not. The court in that case instructed the jury that if they were issued in good faith for the purpose of curing disease or relieving suffering, the defendant should be acquitted. All doctors show good faith in their prescribing. This use of interpretive rule, declaring standard medical practice as outside the course of professional practice in the courtroom, has to be stopped. By using interpretive rule this way, the Attorney General is claiming extraordinary authority. His power would include the greater power to criminalize even the actions of registered physicians whenever they engage in conduct he deems illegitimate. This power to criminalize, unlike the power of registration, which must be exercised only after considering the 5 statutory factors, would be unrestrained. It would be anomalous for Congress to have so painstakingly described the Attorney General's limited authority of registration, but then give him, just by implication, authority to declare an entire class of activity outside the course of professional practice and therefore criminal. The problem with the design of the interpretive rule here is that it cannot and does not explain why the Attorney General has the authority to decide what constitutes an underlying violation of the CSA in the first place. The explanation the government seems to advance is that the Attorney General's authority to decide whether a physician's actions are inconsistent with the public interest provides the basis for the interpretive rule. Now, in Minnesota ex rel Whipple versus Martinson, a physician, in order to be exempt to the Harrison Narcotics Act, this is back in the 1920s, must dispense drugs to none but patients under medical or professional treatment and keep the records for 2 years. If those provisions are complied with, then he has shown the desire to comply with the provisions of the law and his good faith in the dispensing of drugs. In practically every jurisdiction, the federal courts have stressed and made the deciding factor in all cases of physicians in the past the question of the good faith of the physician. Did he dispense the drug to a bona fide patient in the course of professional treatment? Now, if that was the way law was handled in the 1920s, and there have been no laws designed to the contrary, why is this not the case today? The phrase outside the course of professional practice is being used by prosecutors without warrant or evidence, and with the anti-opiate or opiophobia beliefs today. This becomes prejudicial against any physician in the courtroom. This has become so commonplace and accepted among this pro-prosecutorial federal policy that prosecutors are even bragging in the media now about not bothering to prosecute street pushers, but go after the physicians. As a former U.S. attorney explained in her presentation to physicians taking the pain management course offered at Case Western University in Cincinnati, when asked, why are we going after physicians? Why is the government going after physicians? Her answer was, because that's where the money is and the guns aren't. Now, that is no way to run our system of justice in this country, to base prosecution on confiscation of physician income and assets. Now, in Jin Fui Moy versus the U.S., it states, quote, manifestly the phrases to a patient and in the course of his professional practice only. These are intended to confine the immunity of the registered physician in dispensing narcotics and opiate drugs strictly within the appropriate bounds of professional practice, and not to extend it to include a sale to a dealer or a distribution intended to cater to the craving of an addict. So that's a quote. And that basically defines what course of professional practice is. That if a doctor sees a patient, even one who comes in fraudulently, but the doctor is treating him, listening to his problem, and doesn't know that the patient is there fraudulently, he is working in the course of his professional practice. But in the courtroom, they're actually, and in media write-ups, they'll actually say these the government sends in these fraudulent patients, the doctor treats them, and therefore the doctor's guilty. Well, the doctor doesn't know the patient's fraud. He's treating them thinking the patient is honest. Something else I believe that the DOJ is doing illegally in charging physicians for prescriptions that were never filled. Doctors don't realize this. If you make a mistake on a prescription, be sure and get the hard copy back from the pharmacy. In my case, I did make 3 mistakes in the first day I returned to practice and wrote scripts for controlled substances accidentally. I stopped them from being filled, but the script was still at the pharmacy. The DEA collected them and charged me for them, but there were never pills received by the patient. Now, even in the course of arresting street pushers, law enforcement must have evidence of that exchange. But why not for doctors? That isn't necessary, and this is wrong. Another problem that surfaced in my case is the question of confidentiality in patient care. Is it right for a doctor or anyone working in the office to wear a wire as an agent for law enforcement to use against a medical professional? I don't think so. That makes doctors therefore think that possibly their treatment and their confidentiality in their office is at risk, and that could reduce our patient care. So thank you very much for listening to my interview, and I hope that some of the information I have given you will help you make better choices and informing people of the illegal acts being conducted against doctors by our judicial system today.